conference. And so my role here as chair will be limited to giving the floor to the speakers and to look at the time. So please do respect the timetable, because we have a lot of speakers. We will have 4 presentations, one of which is online, and then we have 2 short presentations from other people online. So the session is about rules and procedures on mediation and diversion in Baltic and Northern European countries. And so we are starting from Finland. And so we have the first speaker of the session, which is Riikka Laitinen, which is PhD at the University of Helsinki and is also a district judge. So Riikka, thank you very much, and you have the floor.
Okay, good afternoon, everyone. Well, we are still working on some technical. Okay, we have the presentation also visible for everyone. So I might just start by introducing myself. My name is Riikka Laitinen, and like already introduced, I'm from University of Helsinki. I am a doctoral candidate there. As a day job, I work currently at the Helsinki Administrative Court, actually, and as an assessor there. But I used to work as a district judge before. But here today, I'm presenting as a doctoral candidate. So this is, as a disclaimer, I'm not speaking as a judge, I'm speaking as a researcher from the topic. My presentation is going to be about the Finnish restorative and mediation procedures, and especially from the perspective of financial crimes. And I will start by just quickly going through some restorative processes that we have in Finland. We have the victim offender mediation in criminal matters. That is actually I could say, maybe the core of the mediation practices relating to criminal matters or crimes in general. We also have different kind of mediation practices. And I have added kind of to the list in the end, the plea bargaining and negotiations based on guilty plea, which will be the main topic of my presentation, as it's the one system. It might not be the most restorative one, but it's definitely the one concerning financial crimes and PIF crimes, so to speak. And when is plea bargaining in Finland possible? We have some requirements. It's allowed when the maximum penalty is less than 6 years of imprisonment. And also the other limitation is that it cannot be concerned in crimes against health and life of others and sexual crimes. When implemented to our system, the procedure was said to be applicable and meant to be used in larger scale crimes in which the value of confession or information given by the offender is greater, and especially in financial crimes. That is, this also goes to show in a way the nature of plea bargaining in Finland, and that is the process economy that comes first. The competent authorities that are related to the plea bargaining process are the police, and mainly the prosecutor's office or the prosecutor, and the court as well. So to speak, the procedure is carried out by the same authorities as any criminal proceedings. So it is not very separate from the criminal justice system. Actually, I'm going to take the mask off at this point because it's going to be easier. Yes. And for the defendant, the counsel is always appointed unless specifically the defendant for some reason wants to present himself or herself. we have talked about legal persons. They have, to some extent, they can participate, but in the Finnish criminal justice system, the legal person very, very rarely is a party in the criminal matter. There are some exceptions when the legal entity might be a party in a criminal matter, but usually the criminal liability is personal and it's targeted to the person, the defendant. Also, the legal entity can be part of the plea bargaining proceedings through the damaged party, as the damaged party may participate in proceedings, and one of the preconditions for the proceedings in all is that the damaged party actually accepts the proceedings to be used. So it is a precondition of starting the negotiations. And that, of course, if the damaged party is a legal entity, that might mean that the representation of a legal entity is required. So when starting the plea bargaining proceedings, the prosecutor may, by his or her own motion, or by the initiative of damaged party or some other person or party concerned, take measures to start the negotiations. So it is the prosecutor's decision. There are some things the prosecutor must take into consideration when starting the negotiations. They are the nature of the case, what kind of claims are to be presented, and also this could be the most important part from the point of view of the Finnish legislation, are the expenses apparently resulting from and the time required for a hearing, a plea bargaining in one hand, and also on the other hand, those in the procedure provided for the presentation of charges on the regular criminal proceedings. And also possible questions of the participations in the suspected offense or in an offense directly connected with the crime has to be concerned. And this is to say that maybe if we have several defendants of the same factual actions, it might not be very useful to have plea bargaining for one and the regular proceedings for the others. It's not impossible according to legislation, but it's something that the prosecutor must take into consideration. And to start the negotiations, the defendant must be given all the material, all the evidence or the details collected in the investigations. So it's kind of to know what they are pleading guilty for. And the plea bargaining negotiations are allowed also during the investigations by police, but it is not very common that it is used because of this, that if there's still something to be investigated, the police might not be very interested in giving the details to the suspect at that point, to make sure that there's nothing that would harm the investigations if it's not finished yet. And the prosecutor decides whether the access for the plea bargaining is granted, but the final evaluation of the plea bargaining process is made by the court that will hear the case. But the court has very limited possibilities to refuse the proposal that is made as an end result of the plea bargaining negotiations. After the negotiations, if they come to conclusion that first of all, the defendant is willing to plead guilty and they have an agreement of what has happened and what is the crime about, a proposal for judgment is drafted and submitted. And for that, the preconditions are that the defendant has admitted having committed the suspected offense, and also consents to the hearing of the case in this simplified procedure, and also that the prosecutor and the defendant are agreed on the imputable offense, and also that the damaged party has stated in the criminal investigations that he or she has no claims in the case or consents to the hearing of the case in the plea bargaining proceedings. That is pretty much the mandatory participation of the damaged party. So it does, if the damaged party does not have any claims, not regarding criminal liability or financial claims or other civil claims, then that the damaged party is not considered to be a part of the proceedings. And also in the proposal for the judgment, the prosecutor commits requesting the punishment in accordance with a mitigated scale of punishment, or commits to waiving the prosecution for one or several suspected offenses. That means that this is pretty much the authority of the prosecutor in the proceedings. The prosecutor may state his or her opinion of the type and amount of punishment to be imposed, but this is typical for the Finnish system that the prosecutor and the defendant do not negotiate of the exact actual punishment. That is left to the court. But as I will later explain a bit further, there are some limitations to the court as well. Also, the claims of the damaged party may be settled as part of the negotiation and as part of the proposal for judgment. And like I said, the prosecutor's power is limited, waiving the charges or to the mitigated scale of punishment. And the prosecutor has no power to negotiate the forfeit of the ban of business operations as part of the guilty plea. So they are actually the kind of sanctions that might be very important for the defendant in financial and economic crime. So it's good to understand that they have to be accepted as well. And if before the proposal for judgment is made, if the defendant at some point does not agree with the settlement that the prosecutor offers, the confession and the statements can be cancelled all in all, and they cannot be used in regular criminal proceedings in which the case will return if the plea bargaining proceedings do not come to the end. For the time's sake, I will not go through in detail the actual proceedings at the court. I will just sum it up by saying that it follows pretty much the same pattern that it does in the regular criminal proceedings in Finland in main hearing, even though the proposal for judgments is considered in the proceedings without the actual main hearing, but the steps are similar. It just doesn't have very specific, they don't go through the evidence to the same extent than in the regular criminal proceedings. The main point is to make sure for the court that the defendant is taking part of the proceedings by his or her own free will, and is still consent to the plea bargaining proceedings, and there's no there's no kind of pressure towards the defendant to take part of those proceedings. And the court shall ensure that the case is dealt with appropriately and all the irrelevant matters are not mixed into the case. And the court shall use questions to eliminate ambiguities and deficiencies in the statements of the parties. So it's to control that everything has gone by the book during the negotiations, and the plea bargaining or the proposal for the judgment is appropriate regarding the offense. The judgment that will come as an end result of the plea bargaining proceedings, the court shall issue a judgment according with the proposal for judgment if the defendant has made the admission and given the consent. No reasonable doubt remains regarding the voluntary and valid nature of the admission, taking into consideration also the criminal investigation material, and the court convicts in accordance with the proposal for judgment. So there's no, how to say it, there's no big difference how the court sees the case, what it's about, and how the prosecutor and the defendant has seen the case. And also there's this general clause that there is otherwise no bar to acceptance of the proposal. Also, the judgment shall contain in addition a decision on the other claims based on the offense and connected with the consideration of the case. That could be the claims of the damaged party. No matter at what point of the procedure the guilty plea and negotiations take place, the same mitigation scale is applied. So this is the key element of the Finnish plea bargaining proceedings. What we are seeking for is the use of mitigated scale of punishment, and that it may sound that if the defendant and the prosecutor do not actually negotiate about the actual punishment, what's good for the defendant to take part of this? That is that in the judgment, the court has to explain how the punishment is, how they come up with the punishment as it is. So they have to say that without the mitigated scale, it would be this. But because you have taken part of the plea bargaining proceedings, and so we apply the mitigated scale, so we take it down to this. So there's always the criminal offense is considered as a whole, and then the mitigated scale is applied. And as these proceedings are, when they started implementing this into our system, all the talk was about process economy. And this is a bit kind of a tricky situation in a way that if we talk about process economy, the scale that we have to set for the punishment is the same, no matter what point of proceedings, the regular criminal proceedings, I mean investigations or prosecutors' considerations, it's going to take place. So it can be quite late in the proceedings that they apply the plea bargaining and still get the same benefit than those that started the proceedings earlier. And like I said, the court determines the actual sanction. And for that reason, also the judgment can be appealed and then modified by the Court of Appeal if necessary. For the time's sake, I'm going to skip a few slides about the victim offender mediation in criminal matters, just because it's not relevant to the PIF crimes. It's something that we have that we consider more to be more of a social matter, social services matter than criminal proceedings. It's very separate, and it does not have absolute effect to the criminal proceedings unless it's taken place in smaller scale crimes, in which always the prosecution requires the request by the damaged party. And in the end, I will mention shortly that we also have the other way of reducing the punishment or using mitigated scale than the plea bargaining. And this has been available much longer than plea bargaining proceedings that started in 2015. This has been part of our justice system for decades. That we also have the prosecutor has quite extended powers to waive charges based on reconciliation by the defendant, or then request mitigated punishment if the defendant has assisted in solving the case in the course of investigation. I have added the actual the articles in the slides, but they will be available for you. But the main idea is that the participation of the defendant can be considered as mitigating or reducing factor for the punishment in any criminal proceedings. So I will come to my concluding remarks. 3 short points. The Finnish plea bargaining is not very restorative by its nature. This is my personal opinion, and it's based on why the plea bargaining was started and implemented in our system in the first place. The government proposal talks about a lot of process economy. It kind of forgets the victim in the process. It's part of the preconditions, but it's not very. It can be very small, the role of the victim in these proceedings. And yet again, we have a restorative processes, the victim offender mediation, but it is not very useful for economic or financial crimes, as it's not something that will, the nebis in idem principle will not apply. It doesn't have necessarily any effect, other than maybe some kind of reducing effect in the actual punishment. But I haven't heard that in any case that the mediation offices would have accepted financial crimes in victim offender mediation. It's not very in the core of their purposes. And the third part is that we also, you don't have to go through the plea bargaining. That is, as we heard already from Serbia, that it is very, and some other countries actually today as well, that it is there's a lot of work for the prosecutor compared to the regular proceedings. So this is one of the things that might reduce its application, the plea bargaining application, because there's possible to gain similar benefits for the defendant in regular criminal proceedings. And that is something that might be, and I know that there's been studies in Finland that apply to the direction that it should be considered to have some other aspects to the plea bargaining, to have it more commonly used. If we had some other aspects included in the plea bargaining proceedings, it could be more widely used in criminal matters if the system would recognize other benefits than process economy. And I know some prosecutors already have emphasis on the discussions between the defendant and the victim, but it's not very supported by the legislation. It's mostly up to the prosecutor, him or herself, to make sure that it's the restorative part is part of the plea bargaining proceedings as well. I think I have finished my time.
Yes, thank you.
And thank you.
Thank you very much for this. So thank you for this very clear and precise presentation. So we move now directly to the second one. We have a presentation by Professor Namavicius. Welcome. And we can already see you. And the title of his presentation is Legal Issues of VAT Fraud from the perspective of Lithuania. So thank you very much, Professor Namavicius, and please, you have the floor.
Thank you, Professor, and thank you for the invitation. Maybe a short introduction. My name is Justas Namavicius. I am scientific assistant in Vilnius University and also judge in Lithuanian Court of Appeals. And my topic is about some cases from the VAT fraud, what we have here in Lithuania. And I will try to share my screen. And I hope you can see now my presentation.
Yes, thank you.
Okay, thank you. First of all, I will explain in few words the functioning of the VAT taxation in the trading chain. Then I will discuss some selected legal problems we have in the Lithuanian practice. And finally, I will present you two situations, how such VAT fraud mechanism can be embedded into the regular commercial activities of a company. On this slide, I illustrated a very simplified, very simple example of a chain of supplying goods and services, calculating 21% VAT, which is regular in Lithuania. Well, the main idea is that the end consumer pays the VAT, and he pays it in form of price markup to the seller. So the supplier has to discharge the paid VAT to the state budget. The VAT has to be paid only one time, but its amount can increase by the creation of additional value in the supply chain. So here, if we have a manufacturer, he charges the VAT from the price of 100 euro, so 121, if it would be 21% VAT to the state budget as so-called output VAT or sales VAT. If the supplier resells, if the manufacturer resells the good to the supplier, and the supplier resells it at the higher price, so for example 200 euro, he has also to discharge the additional value from the end consumer. Indeed, he can deduce the VAT from the obligation which he has already paid to the manufacturer, the so-called input VAT. So he pays only the additional value, so it would be here double price, so next 21 euro. And he pays it then to the state. And in the end of the day, I don't know, you can see it or not, but in the end of the day, the final consumer pays the whole amount of VAT. It would be then 42 euros. So 21 euro here, 21 euro there on the chain. So it's very simple model. Of course, the chain can be much longer and more complicated. The analog mechanism works also with the re-exporting of goods. The supplier can claim from state the paid VAT if he exports the goods to another country. It's also a common model for the taxation. Well, the specifics of the VAT that the supplier charges it on behalf of the end consumer can be a trigger for dishonest business people to manipulate the taxation process and to enrich themselves to the detriment of the state budget. If we talk about the basic types of the VAT fraud, it has to be noted that you can manipulate the tax on the side of the output, so sales VAT, which the undertaking has to discharge to the state, as well as on the side of the input VAT if you cause damage by the illegal deduction. the simple version is when the supplier sells goods and charges VAT from the buyer, but does not declare or declares the lower output VAT to the tax authority. Indeed, avoiding of the output tax payment can be part of a transnational carousel fraud, also so-called missing trader fraud, which involves many persons and sometimes also several countries. So in all this chain, you have to have at least one person who does not discharge this output VAT. In rare cases, avoiding the output tax is also possible by intentionally bringing the undertaking towards bankruptcy. But in the criminal proceedings, practical difficulties may arise when it comes to proving the causation as well as the specific intent. A very popular form in Lithuania is to manipulate the VAT on the stage of deduction of the input VAT. It is popular because in its simplest version, it does not require too much criminal energy and know-how. However, it can also be part of complicated mechanisms. Well, the idea is that mostly a fictive company or companies include in their accounts the contracts about no existing goods or services with a company which conducts real commercial activities. The real company declares a fictive input VAT to the tax authority and in such way increases its revenues by the fraudulent deduction of the input VAT from its regular tax obligations. So in form of a refund or the reduction of the payable taxes to the budget. In some cases, the fraud can also be continued in the chain of false deals. So actually you have some fictive contract. There are no goods, no services, but you get then by these mechanisms of the fictive input VAT a claim against the state to reduce your tax obligations or maybe also refund. In that way, then you can save your own money for your another real activities. And here we come to the first legal question. So there is one interesting point by this mechanism that the fictive company, I called it here supplier number one, has to pay the output VAT. So, but in reality, it does not happen. This output VAT is of course formal because it's made by fraud. The undertaking just disappears soon after the contract, or it gets just bankrupt. It's only just made for this. You know, there are some people in Lithuania who earn their money only by founding and selling such letterbox companies for such deals and another deals. And the problem is, can the avoiding of this only formal output VAT by the fictive company be qualified as tax fraud? In some cases, the public prosecutor charges it as a crime. Well, the answer is no, because the fictive trade does not accumulate any value, so there is no obligation to pay the output tax. So you have this fraud only on the stage of the real company, supplier two, who manipulates the input VAT. Second legal question is more interesting. In some cases, the buyer of a fictive contract pays real money to the alleged seller. So actually money for nothing. You have no services, you have no goods, but he pays money for them. On this way, the participants hope to hide the fraud because they can present the money transfer to the tax authority in their financial records. They say, here, look, the money was gone. But it makes only sense in a fraud, in all this fraud scheme, if this money comes back from the fictive company back to the real company. Of course, this transfer is not reflected in any records. So sometimes they do it just cash and bringing this money back. The question is how to assess this refund of money. In some cases, the public prosecutor argues that supplier number one, the fictive undertaking, should be punishable for the misappropriation of the property of its company. I have my doubts because the money actually de facto never changed the owner, the real company, the supplier number two. In that case, the fictive supplier, this fictive company just keeps the money in transition. So theoretically, money laundering could also come into play, yet it is also doubtful because the money serves only as an instrument of the VAT fraud mechanism. The primary source of this money can be completely legal, so it does not become dirty by the circular transfer. It's just like a car which you drive to commit some crime. That's all. But it's my personal meaning about that. And the third legal issue concerns the destiny of the money, which the company may illegally accumulate from the VAT fraud. It is uncommon that the fraudulent company just transfers this money away from himself, for the third people, but away from the company. In some cases, yeah, the judicial practice assesses this transfer of the revenue from the VAT fraud from the company also as the misappropriation or the squandering of property. Possible is also the money laundering. The problem of such viewpoint is that this revenue is already acquainted by the criminal offense of the VAT fraud. Also, formally, the money remains the property of the company, but the additional sanctioning may infringe the non bis in idem principle. In any case, the third person where you give this money, who obtains this transferred benefit, it may be punished. So by all the crimes as misappropriation, as money laundering, what you want, but by the offender company, it seems to be, I would say it seems to be problematic, but we have had such decisions. That's about the legal problems. And finally, I will just present you two cases which I just found interesting, that sometimes the fictitious commercial operations can be embedded in the parallel real operations. So in first case, which I have had in my hands, the undertaking developed the commercial facilities, and both real building and real installation services from the real undertaking. So they built something, they bought some machines, some stuff, and that was okay. But at the same time, it declared false receipts of services from fictitious companies, but for the same services, for the same works. The documents were one by one identical with regard to the purchasing of services and prices, but one group of contracts was real, another was fictional. I did not until the end understand why. Maybe it was to conceal the fraud, concealment of the fraud. The company could present to the tax authority so real commercial results. They would say, here, look, they are really buildings, they are really machines, everything we do is okay. What was very interesting in this case, that they seemed, I'm not 100% sure, but they seemed also to have two parallel cash flows. One was from the regular money of the company for the regular activities, and the other was from the credits of the main shareholders for, I would say, questionable activities. So we have had two, so I would say, money, cash flows, or I don't know. So it was very smart mechanism, very smart to hide. And another aim of this mechanism was maybe just saving the money for the real commercial activities, what we're doing. Meanwhile, the legislator established the so-called reverse charging of VAT for the building services, where the taxes has to be discharged by the buyer, by the commercial buyer, not by the seller, to avoid this art of tax evasion. And in the second case, which is now pending with one district court, for Lithuania, they charge a big damage. It's more than 7 million euro of taxes. It's for Lithuania quite big amount. And it was interesting that the undertaking may use the saved VAT money, which he has had from this fraudulent operations, to subsidize the price of real sales of gasoline, and in such a way get the competitive advantage. The logic behind those operations is still not precisely clear, but we will wait for the final decision. To sum up, it will be interesting to see how the judicial practice will evolve with regard to a legal assessment of the VAT fraud. And I say thank you for your attention.
So thank you very much, Dr. Namavicius. And we move now to the third presentation by Julia Innerhofer from Austria. And the title of her presentation is very appealing because it's Diversion as the Ideal Simplified Prosecution Procedure for PIF Crimes in both Austria and Germany. So thank you very much, and you have the floor.
Buon pomeriggio, grazie per l'invito, and good afternoon to all of you. My name is Julia Innerhofer, and as has already mentioned, the title is Diversion as the Ideal Simplified Prosecution Procedure for PIF Crimes in Austria and Germany. And therefore, the aim is to present you the relevant legislations of Austria and Germany and to discuss if their respective simplified prosecution procedures can be seen as ideal, especially in the light of the PIF crimes. First, I will shortly recap the starting point of our examination, which is the EPO and its provision on simplified prosecution procedures. And next, I will explain the relevant simplified prosecution procedures of Austria and Germany, and also their conditions, and show you their applicability to the PIF crimes. And after that, I will guide you through the procedures in Austria and Germany from the initial suspicion of a crime until the final conclusion and its effect. And at the end, I will shortly give you some insight on the impact and relevance of the procedures in the two countries, and also highlight some pros and cons of these procedures. Yeah, as we all know, the APO has been established by the Council regulation on the APO to combat and prosecute the PIF crimes, which are set out in the directive on the PIF crimes and concern the union's financial interests. And Article 40 of the regulation states that simplified prosecution procedures found in national laws may be applied in accordance with the conditions from that national laws. And the article also clarifies that such simplified prosecution procedures must aim at the final disposal of a case on the basis of terms agreed with the suspect. So I therefore have to examine if the legislations of Austria and Germany contain such simplified prosecution procedures with these two prerequisites. On the left side, you can see the relevant simplified prosecution procedures of Austria. Section 198 of the Austrian Code of Criminal Procedure is the key diversion method for natural persons, and Section 19 of the Corporate Criminal Liability Act is the corresponding provision for legal persons. And the German provisions are listed on the right side. Here, Section 153A of the German Code of Criminal Procedure is the most important one when it comes to diversion for natural persons, and can also be compared with the relevant Austrian one. Section 30 of the Act on Regulatory Offences concerns legal person, but it's not a real diversion method as Austria has in Section 19. It's rather something between diversion and criminal punishment as a regulatory fine is imposed. And Germany also has Section 398A of the Fiscal Code, which concerns the refrainment from prosecution in certain cases of tax offenses. And it's interesting that, on contrary, in Austria, tax offenses are excluded from diversion. I will focus today, at least, on Section 198A of the Austrian CCP and Section 153A of the German CCP. Okay, let's have a look at diversion for natural persons in Austria. As I've said, it is regulated within Section 198 of the Austrian CCP, and there are several conditions that have to be fulfilled in order for a case to be open for diversion. The first prerequisite is that the facts have been sufficiently cleared up, and moreover, a discontinuation of proceedings under Sections 190 to 192 CCP is out of question. And this concerns, for example, closures due to a lack of factual grounds to prosecute or cases of trifling nature. Moreover, punishment must not appear warranted in order to prevent the accused or deter others from committing criminal offenses in light of the application of a diversion method. And therefore, a diversion method of Sections 200 to 204 CCP must be deemed suitable for eliminating the public interest in this. The offense must also not be punishable by more than 5 years of imprisonment. And lastly, the culpability of the accused would not be considered serious. So this provision is pretty vague, but in essence, this means that aggravating and mitigating factors are weighed up, and also the culpability, the esteemed culpability, would be compared to the usual one considering these crimes. Now that you've seen the conditions for natural persons, I will quickly compare them to the ones relevant for legal persons. They are entailed in Section 19 of the Corporate Criminal Liability Act, and it is based on the CCP but differs in certain respects. So also with legal persons, the facts must have been sufficiently cleared up, and a discontinuation of proceedings under these Sections 190 to 192 must be out of question, and the same goes for an approach pursuant to Section 18 of the Corporate Criminal Liability Act, which is something very similar. Yes, and prevention also plays a big part within the diversion method for legal person, and therefore there's a prevention clause that states that the imposition of a fine must not appear necessary in order to prevent the commission of criminal offenses for which this legal person or any other legal person would be held liable. Also, in respect to the application of a diversion method, the offense must not be punishable by more than 5 years of imprisonment, And while 198 of the Austrian CCP doesn't mention damage rectification within this section, although it plays a role in respect to certain methods, as I will explain later on. Section 19 explicitly mentions that the legal person has to repair the damage, remedy other consequences of the offense, and prove it without delay. The relevant section 153A of the German CCP is not called diversion, although it can be seen as a form of it. And it's also not as exhaustively regulated as the Austrian provision, but there's still certain conditions that have to be fulfilled. For instance, it's only applicable to less serious criminal offenses, which means that they are punishable by a minimum term of imprisonment of less than 1 year or by a fine. And prevention is also important in Germany, and therefore the imposed condition or direction has to be suitable for eliminating the public interest in prosecution. And lastly, the degree of guilt would not be deemed serious, which is just as vague as the Austrian provision. With respect to the mentioned conditions, we can see that Austrian diversion is not applicable to all PIF crimes. I will not go into detail here, as we don't have the time, but the main reason for the non-possibility is the sentence range. And moreover, some of the PIF crimes can be found within the Austrian Financial Crimes Act, for which diversion is explicitly excluded. And when we look at Germany, it's notable that almost all PIF crimes are resolvable under the diversion mechanism, and there are only 2 exceptions due to the sentence range. Okay, after having cleared up the conditions and the applicability, let's dive into the procedure for natural persons. And in Austria, it all starts with the initial suspicion of a crime, which triggers the preliminary investigation. And in this stage, the public prosecutor's office would normally conclude that he or she found the suspect, and if an acquittal is less likely than a conviction, he would file an indictment. But if all prerequisites for diversion are met, he or she may instead propose a diversion method to the accused without needing the consent of the court. Possible methods are in Section 200, the payment of a sum of money, which would go to the Republic of Austria, Section 201, the community service, Section 203, probation, or Section 204, victim offender mediation. And the accused can either reject this proposal, which would lead to an indictment, or accept it, which is why it is based on voluntariness and happens on terms agreed with the suspect, as Article 40 of the regulation demands. The acceptance of the accused would then lead to a provisional withdrawal from criminal proceedings. Then the accused has to comply with the agreed diversion method, which has to be one of the just mentioned ones. And this method cannot be confused with the rectification of any damage. So these are 2 different pairs of shoes, if I may say. But however, sections 200, 201, 203, and 204 describe that the withdrawal from prosecution must or may, depending on the specific agreed method, be made conditional upon the accused rectifying any damage caused by the crime within a set deadline of not more than 6 months. And as no specific amount or proportion is regulated, this has to be interpreted. And one should think that the whole amount must be covered, but only Section 200 can be read that way, because Section 201, which regulates community service, also mentions the whole amount, but stipulates an alternative, as it also includes the option that he or she contributes to the compensation of the consequences of the act. Section 203 mentions the fulfillment of certain duties, which could but not has to involve the effort to rectify any damage. And the same can be said for Section 204, as the accused must rectify the consequences of the act, but it doesn't refer to the whole amount, and it also doesn't only refer to a real damage. Considering this, Section 200 is probably the most efficient when it comes to damage rectification. And for particular reasons, it's also possible to waive this condition altogether. So damage rectification is not always mandatory in Austria. The restitution is part of the alternative proceeding, so it is proposed and initiated by the same authority that proposes the diversion method, and it also has to be verified without delay. Then after complying with the method, the proceedings will be finally closed and the accused may not be tried for it again. So also the second condition, the final disposal of a case as set in the regulation, is met. The decision of the public prosecutor's office is not appealable, and diversion can be seen as a form of sanction, but not as a punishment, as no guilt is pronounced, and therefore it's only registered in an internal register, but the person gets no criminal record. Let's go through the procedure in Germany real quick, as it is pretty similar, but there are some differences. It also starts with the initial suspicion of a crime and the preliminary investigation. And within these, the public prosecutor's office may propose the alternative procedure instead of indicting the accused. But contrary to Austria, the German public prosecutor needs the consent of the court, unless in the case of a less serious criminal offense, which is not subject to an increased minimum sentence, and if the consequences ensuing from such an offense are minor. The accused can also in Germany reject or accept the proposal, which is why it is also based on terms agreed with the suspect. And the acceptance also here leads to the provisional withdrawal from criminal proceedings. After that, the accused has to comply with the agreed method, and this could also be the payment of a sum of money or community service, but also damage rectification. So in Germany, damage rectification is one possible diversion method. After complying with the procedure, the proceedings will be finally closed and the offense can no longer be prosecuted as a less serious criminal offense, which is why also in Germany, the second condition, the final disposal of a case, can be seen as fulfilled. And also here, the decision of the public prosecutor's office is not appealable and is considered a sanction and not a punishment, which is why also in Germany, it's registered in an internal register, but the person gets no criminal record. I've put some numbers on this slide to give you some insight on the impact and relevance in the two countries. And if you look at Austria, you can see that in 2019, there were 241,473 final closures of proceedings. And out of these, 49,192 were due to diversion. In contrast to this, there were only 30,356 convictions, and diversion is even more prominent than convictions and acquittals combined, which shows just how important this method is in our legal system. And when we look at Germany on the right, we can see that the number of indictments is higher than the number of closures under diversion. And the reason may be found in the high numbers of other closures of proceedings. So there are several options which do not play a part in respect to the PIF crimes, but generally there are several options, and also that of summary punishment, which is also not a diversion method. So it's relevant in both countries, but especially in Austria. You can also see that in both countries, the alternative procedure can not only be handled by public prosecutors, but also by courts after an indictment. So this is also an option, although most cases are handled by a public prosecutor within the stage of preliminary investigation. And to conclude, I will quickly highlight some pros and cons of diversion procedures in Austria and Germany. And as the procedure predominantly takes place before the public prosecutor's office within preliminary investigations, they're usually very quick and cost efficient. And there's also a high possibility of damage rectification, which is a huge advantage for the victim. And concerning the accused, diversion is based on voluntariness and lays its focus on prevention and reintegration. And as he or she gets no criminal record, it's further beneficial for him or her. On the other hand, it is not suitable for serious crimes or for all types of crimes sometimes due to the sentence range, the law, the degree of guilt, or would not have a sufficient deterring effect. And as I've already said, damage rectification isn't always mandatory in Austria or Germany, so this is a con. But I would say that even if diversion in Austria has its flaws and it cannot be used for every possible PIF crime, it's still a very good method, and in my opinion, the almost ideal simplified prosecution procedure. Thank you for your attention, and I'm looking forward to hearing more about the possible procedures in your respective countries. Thank you.
Thank you very much for this very exhaustive presentation. And you also succeeded in respecting the time,
Great.
the 20 minutes, notwithstanding you had 2 countries to analyze. Thank you very much. So before I forget, I have 2 announcements to make. The first one is that in the website of the project, dramp.eu, you can also find the book of abstracts. It has already been published. And the other announcement is about a key. A key for a car has been found, so please check your pockets. If you have lost the key, it's just outside at the desktop. I think it is a Fiat, maybe a Fiat car. So just please check. Yeah, a more important announcement. So we move now to the 4th presentation. So we move now to Belgium, and we have a presentation by 2 speakers, Sam Carrel, which is here, and Gent de Smet, which is here online. Thank you. And so, Sam, please, you have the floor.
Thank you very much, Mr. Chairman, for the kind introduction. I'm just waiting for the slideshow to arrive. Good afternoon, everyone. Buongiorno a tutti. I'm also very glad to be here. And on behalf of my colleague, Gent de Smet, and myself, I would like to thank the organizers of this conference for inviting us to participate, as well in this interesting research project and the conference too. As you can see, I'm the only one sitting in front of you today. My colleague, Gent de Smet, will do her part of the presentation online, but I will remain responsible for the utmost stressful task of switching slides. Our presentation is structured as follows. First, I will give some necessary background on Belgian criminal law. Next, I will briefly present the 4 relevant alternative dispute resolution procedures that can be applied for criminal offenses falling under EPO's competence. I will also highlight some issues along the way and their practical relevance for EPO as well. After that, Gent will take over and elaborate on the most relevant one, namely the transaction. But let's start with a short introduction to the Belgian criminal justice system. In Belgium, criminal offenses can be subdivided in 3 categories. From less serious to most serious, they are crimes, they are contraventions, misdemeanors, and crimes. If there are many mitigating circumstances, such as, for instance, the absence of any prior convictions, this can result in a denaturation of the criminal offense and, consequently, in a lower penalty. For instance, a criminal offense defined as a crime in the law can, because of the application of mitigating circumstances, become a misdemeanor and be punished accordingly. Normally, crimes need to be referred to the cour d'assises for a trial by jury, but in practice, the application of mitigating circumstances is very often and actually quite artificially used to avoid this costly and burdensome procedure. Next, legal persons can, just as individuals, be held criminally liable under Belgian law. And in criminal procedure, the opportunity principle is applied, which means that the prosecuting authorities decide whether a suspect should be prosecuted, but also which form the prosecution should take, and therefore whether alternative dispute resolution is appropriate. They can also decide to just dismiss a case, which is in practice the type of alternative dispute resolution which occurs the most. There are more and more exceptions to this rule, but in principle, the investigation remains written, secret, and non-contradictory. And lastly, A distinction has to be made in the investigation phase between an investigation led by a public prosecutor on the one hand and a judicial inquiry led by an investigating judge on the other hand. In current practice, a large majority of criminal investigations are led by a public prosecutor, but judicial inquiries remain relevant for cases where investigation measures which form serious infringements of human rights are required, such as a home search warrants. After the end of a judicial inquiry, an intervention by an investigation supervision court is required as well. This court will only refer the defendant to the trial court if there are sufficient indications of guilt. There are 4 types of alternative dispute resolution in criminal matters, which can be considered as simplified prosecution procedures as referred to under the APO regulation. These are the transaction, the guilty plea, the penal mediation and measures procedure, and the rewarded cooperating witness/offender regime. The transaction, in essence, requires the defendant to pay a certain amount of money, and possibly also to surrender certain goods. The penal mediation and measure procedure requires the defendant to comply with certain measures or conditions agreed upon with the public prosecutor. These conditions and measures can be the attending of a training course, medical treatment or a therapy, compensation or reparation of the damage caused, as well as the performance of public services. They can be proposed separately or together. Thirdly, the guilty plea, in essence, is an agreement between the public prosecutor and the defendant on the penalty, whereby the defendant admits that he's guilty of the criminal offenses forming the subject of the agreement. This procedure was introduced in 2016. And lastly, we have the, in 2018, introduced rewarded cooperating witness/offender regime, which requires the defendant to provide substantial information and cooperation to certain criminal investigations concerning serious criminal offenses in exchange for reward. That reward can be a more favorable treatment of the criminal case, such as, for instance, a reduction of penalties. 3 remarks need to be made in this regard. First of all these procedures are based on the voluntariness of the defendant. They cannot be imposed. Secondly, as a consequence of the opportunity principle, it is the public prosecutor who triggers or proposes one of these procedures. In practice, the defendant or his lawyer often requests it, but the public prosecutor, the prosecuting authorities, do not have to accept this request, they can reject it. They do not have to motivate such rejection, and there's no legal remedy available against it. And lastly, all these procedures can be applied to both individuals and legal persons. However, given the nature of the penal mediation and measures procedure, it seems rather unlikely that's applied to legal persons. I will not delve too deeply into too much detail here, but here you can see all the conditions, consequences, and the legal basis of the 4 procedures I just mentioned. Do note that there's almost always a condition relating to the nature of the criminal offense committed by the defendant. Because of the application of mitigated circumstances, the threshold of 2 years or 5 years will not very often be a hurdle for any of the criminal offenses falling under APO's competence. There's also always a certain procedural scope during which the procedure can be proposed. And for a transaction and penal mediation and measures procedure, there's a condition relating to civil liability as well. There are some additional conditions regarding tax offenses for the transaction, which my colleague Jente will discuss shortly. Both the transaction and the penal mediation and measures procedure result in the abandonment of prosecution. The public prosecutor can no longer prosecute the defendant involved. The guilty plea and rewarded cooperating witness/offender regime, on the contrary, result in a criminal sanction in a sentence after ratification by a judge. As promised, some short critical remarks regarding the Belgian approach as well. There's often only a minor role for the victim. For instance, as regards the guilty plea, the victim is only heard for the first time at a court session organized to ratify the plea agreement. There's very often a judicial review required, where, among others, the proportionality of the sanction and the voluntariness of the defendant are assessed. For the guilty plea and the rewarded cooperating offender regime, this is always mandatory. For the penal mediation and measure procedure and the transaction, this is only the case when the agreement was closed after the criminal proceedings have been initiated. One can wonder whether this criterion is really adequate and whether a judicial review should not be in any case necessary for certain serious criminal offenses, regardless of the fact whether criminal proceedings have been initiated or not. The legal framework is sometimes a bit flawed as well. This is especially true for the rewarded cooperating witness/offender regime. There is, for instance, no legally prescribed right of access to the criminal file, despite this being vital for voluntary consent, of course. And lastly, more transparency is often desirable as well, which is especially true for the transactions regarding tax offenses in DTS. I will now shortly say a few words on the practical relevance of all these procedures for EPO. According to the most recent official statistics, a large number, 8.02%, of closed criminal cases were ended by way of a transaction in 2020, including some cases regarding financial crime. I added this number as well, that since 2011, over 955 million euros were collected by way of a transaction, and this does not even include the transaction closed during the investigation led by a public prosecutor, to underline the practical importance of this procedure for Belgium. The penal mediation and measure procedure, on the other hand, is not applied for financial crime, as we can learn from the same statistics, and the guilty plea and rewarded cooperating witness offender regime have only rarely been applied so far. One of the reasons could be that they are less attractive for a defendant and that they are more time consuming for the public prosecutor compared to the transaction. With this, I have reached the end of my part of the presentation, and I now gladly give the floor to Jente.
Thank you. I hope you can understand me.
If everything goes according to plan.
Can you understand me? Can you maybe give a sign if you understand me? Hello, can you understand me?
And as already announced, she will elaborate on the transaction, which is the most relevant procedure for EPO regarding financial crime.
Do you hear me right now?
We can hear you.
Yeah?
Yes, Jente, we can hear you perfectly.
Okay, thank you. Okay, I'm sorry. Like my colleague Sam explained, the transaction occurs to be the most relevant ADR procedure in PIF crimes, and therefore we are now focusing on this procedure, which is also known as the abandonment of prosecution upon payment. Article 216 bis of our Belgian Code of Criminal Procedure lists the conditions for admissibility to this transaction. The first condition relates to the nature of the offense. First of all, the transaction is possible for facts that constitute a serious violation, is not possible, for facts that constitute a serious violation of the physical integrity. And this means that of the offenses that can fall under EPO's competence, no transaction is, for instance, possible in case of theft when it is committed using threats or violence. So it is also not possible for offenses in the field of customs and excise duties. Secondly, the facts underlying the case must be of such a nature that the public prosecutor would not demand a principal penalty of more than 2 years of imprisonment if the case would be brought before a criminal court. And these 2 years of imprisonment do not refer to the legally defined penalty in the criminal code itself, but concerns the penalty like we call in abstracto. So this means that, for instance, mitigating circumstances can be taken into account. The second condition relates to the criminal proceedings. So it must be possible to legally as well as factually conduct a criminal prosecution. This means that there can be no prescription of the criminal prosecution or, for instance, insufficient indications of guilt. And the transaction is possible as long as the trial tribunal or court has not yet taken a final decision in first instance. The third condition concerns the damages. So the accused must acknowledge his civil liability in written and must provide evidence of the compensation of the uncontested part of the damage. A transaction in case of, for criminal offenses which constitute tax fraud or social fraud is only possible after the accused has paid the tax or the social contribution dues after the tax or social administration approves the transaction. This means that, for instance, for VAT fraud falling under EPO's competence, the approval of the Belgian VAT tax authorities is required before a transaction can be entered into. The public prosecutor is free to determine the amount of the transaction within its legal limits. So the amount of the transaction can never be more than the statutory maximum fine. If the applicable provision does not provide for a fine, then we have in Belgium a conversion mechanism in our criminal code, which is also used to determine the amount of the fine for instance, legal persons. There is no minimum amount of the transaction, but the amount should be proportionate to the gravity of the offense. In what follows, I will focus on some specific aspects of the transaction in light of ADR mechanism for the European Public Prosecutor. So firstly, we will focus on the possibility of judicial review. Secondly, we will have a look at the rights of the suspect in the ADR procedure. And thirdly, we will shortly explain the consequences of a failed or a successful transaction. As regard to the judicial review, in case of a transaction, a difference needs to be made between the stage of the preliminary investigations led by the public prosecutor on the one hand, and the stage where the criminal proceedings have already been initiated on the other hand, like Sam also already explained. If the transaction is closed during the investigation led by the public prosecutor, then no judicial review will follow. But if the transaction is closed while the criminal proceedings have already been initiated, then the transaction needs to be ratified. And the judicial body reviewing the transaction will be a investigating supervision court or a trial court, depending on the stage of the procedure. The competent judicial body will verify, like you can see on the slide, whether the conditions are fulfilled, if the victim and or the tax and social authorities have been compensated for the damage caused, whether the proposed transaction was agreed with in a free and an informed manner by the defendant, and if it is proportionate to, for instance, the gravity of the criminal offense and the personality of the defendant. Even though the suspect relinquishes his right to an adversarial trial by agreeing to a transaction, then he or she still has some procedural safeguards for a fair trial. It is vital that the defendant voluntarily and in an informed manner agrees with the proposed transaction. And therefore, he has, of course, the right to legal counseling, as well as the right to have access to the entire criminal file, and they can also copy it. In case of closing a transaction, the prescription of criminal prosecution shall be suspended as from the proposal of the public prosecutor or as from the request of one of the parties. The consequences of a successful or failed transaction are also very interesting to have a look at. In case of a failed negotiations regarding a transaction, the oral statements and documents that were made in course of the formal negotiations cannot be used against the defendant and are not admissible as evidence. In case of a successful transaction, the defendant does not formally admit guilt to the criminal offense by closing it. If the criminal proceedings had already been initiated before the agreement was closed, then the transaction will be entered into the criminal records. However, it will not appear on the extracts that may be issued to the offender, which will have, of course, a positive impact on the rehabilitation of the defendant. Transactions closed during the preliminary investigations are not entered in the criminal record at all. The payments of the transaction cannot be considered as a criminal sanction under Belgian criminal law. However, according to the Engel criteria, it will be a sanction which will make nebis in idem applicable, the principle of nebis in idem. So we can conclude that Belgium has 4 different ADR procedures. However, the transaction will be the most relevant alternative dispute resolution procedure for EPO in Belgium. And with this, we have reached the end of our presentation. Thank you very much for your attention.
Oh, thank you very much. We have now two short presentations online. The first one is from Dr. Erika Varadi-Ksema. Only one. And she is professor of criminology and mediation, and she is from Hungary. And she is also chairman of the Research Center for Alternative Conflict Solution and Dispute Resolution. So thank you very much. We can see you. And please, you have the floor.
Yes, thank you. And first of all, I would like to share the greetings of my colleagues from the University of Miskolc, and of course of our deans. And I would like to say thank you for the possibility that I can personally or online take part at this very interesting conference. In my presentation, I would like to speak about some words about the criminal mediation in Hungary. Of course, the other topics, diversion or restorative procedures, is interesting in connection with the topics of this research or this project. But I think so that the criminal mediation is the most important possibility in Hungary in connection with these questions. I hope my presentation is good and you could see and hear me. I hope.
Yes, we can see you and we can hear you very well. Thank you.
Yes, thank you. Okay, so only some words in connection or about the historical roots. We have different rules in connection with the mediation or the alternative conflict management, and there are different techniques in Hungary, and these exist, especially the mediation exists good among the actors of economy, but without criminal legal consequences or relevance. In connection with mediation in criminal cases, we know that there are the two important group or model, and our mediation system and our legal backgrounds belong to the so-called normative model, because the practice of mediation is based on different criminal acts, especially on the acts of criminal code and or on the criminal code and on the code of criminal procedure, but we have a special acts in connection with criminal mediation too. So our system has a general comprehensive regulation. And the second is that which phase is important in connection with criminal mediation. In Hungary, this is only the phase of prosecution in connection with criminal procedures, of course, and our acts don't give the possibility to use mediation as a part of criminal procedure in the police phase or by the help of a judge. Usually the practice-based models or the countries with these practice-based models give the possibility to use mediation in the different stage of the criminal procedure, but in Hungary this isn't exist. the regulatory background of mediation, as I said, there are three different acts. The most important is the criminal code, and the second is the criminal procedural code, and the other acts inform us about, for example, the institutional background and the actors of mediation process in criminal cases, and about the circumstances become a mediator in connection with this. The legal consequences of mediation according to the Criminal Procedural Act is in connection with the traditional form of mediation, that this is a ground for extinction of offenders' criminal liability, or in the second possibility consequence is that it may be taken into account as an special circumstance. The different acts has different rules in connection with criminal mediation. The criminal code informs us about the active repentance, and this is the so-called traditional form of mediation, because this existed from 2006 or from 1st January of 2007, but in this form, the scope of relevant crimes are limited. The second possibility is the new form of mediation. This is from, or the legal background exists from 2018, and this applicable to any crime is or can exist or could exist the mediation, but unfortunately we can say that this is only in principle and not in the practice. The mediators are in connection with criminal cases special experts, belong to the special institutions. These institutions is a state institution, and not only the mediators in criminal cases belong to this institution, to this office, but for example to other actors of crime prevention, and the other actors who could help to the offenders. And the changes in the recent time is the first is that we get now the possibility to mediation not only in connection with crime or criminal cases, but in connection with infringements too. And so these acts or activities against the law is not so serious cases as criminal cases, of course. The mediation, or this is maybe interesting, the mediation in the financial crimes or in connection with the financial crimes. In Hungary, there are several crimes which is could be important or relevant in connection with our special topic, but there is, for example, economic fraud or budget fraud or money laundering, and some of these is important in connection with the financial interest of EU too. But What we can say about the mediation in connection with financial crimes, that unfortunately in the practice, there is no example of the use of mediation in criminal proceeding. And it's very interesting. Why? Because there are no rules to exclude mediation in Criminal Procedural Act. And the causes depend, of course, on the form of criminal mediation. In connection with the form of mediation, there are, for example, or these causes are, for example, the strict legal framework or the taxative list of crime groups, and or, for example, the relatively low penalties or low level of penalties, and the most part of financial crimes don't belong to this group. But maybe it's more interesting the new form of mediation because it is not linked to active repentance, but it can be used in criminal proceeding for any offense. So in connection or in the criminal procedure of the financial crimes or the criminal activities with the most higher dangers too. But unfortunately, we cannot or couldn't find example from the practice for this. And it's really important that the possibility, we have the possibility, but this possibility exists in principle, and we have to organize deeper research among the prosecutors why they don't use this possibility, because it depends from the prosecutors. The situational is some words about the situation of legal persons. The criminal liability of legal persons is existed in Hungarian criminal law, of course, but we have a special act or separate act for these legal institutions or persons, legal persons. Our act gives three types, or has the three types of criminal measure which are applicable to legal persons under or among these or under this special criminal procedure. This is dissolution, restriction of the legal person's activity, and the fines that in the praxis, the most important legal consequence or sanction or measure, criminal measure, is the fines. Neither the Act nor any other law contains any provision about alternative dispute settlements concerning the legal person's criminal liability. And only some words about the last phase. This is the new challenges of the 21st century.
Yeah, sorry, you have a couple of minutes.
Okay.
If you may conclude, please.
Conclusion is that the mediation officially has a special and but success story in Hungary, and we have to develop our praxis focusing on the financial crimes. And thank you for your attention once more. Thank you.
So thank you very much. I think now we have the coffee break, but before, maybe there are some questions. Yes, please.
Thank you. I haven't seen in your report description of your systems, particularly in Germany and Austria. At which time the European Commission intervenes? Finally, is the European Commission responsible for recovering the funds, fighting against fraud, recover the funds? So she is the one who has to be consulted before any decision is taken, either by the national delegated prosecutor or by the permanent chamber who gives the final agreement. Is there any provision concerning the intervention of the European Commission? If not, I would ask Professor Lanciotti maybe to introduce this aspect in the study because it's very important. I mean, the delegated prosecutor cannot decide to make a transaction, to compromise without asking the Commission whether this is appropriate in terms of financial loss. And also the permanent chamber, before giving the agreement to delegated prosecutors, should also ask the Commission whether they would agree. So I think that there is this dimension which lacks in your study, and I think that you don't have any answer to that. So I would wonder if it would not be interesting and necessary, if I would say so, to put to add this aspect in the research. Thank you.
So this relationship between the delegated prosecutor, or we'll put that down. The relationship between the delegated prosecutor and the chamber was not the focus of my report, of course, because my job was to present you the relevant legislation of Austria and Germany. But I would just say that the delegate prosecutor, after having cleared up all the facts and after he or she gathers and analyzes all the evidence relating to this crime, then the delegated prosecutor thinks about if it would be appropriate to use the simplified prosecution procedure. If not, then it's not available. But then the delegated prosecutor can propose it to the chamber and it will be decided on this level. So of course, they can say, no, it's not applicable, but the first step is in the member state. So that's what the regulation says.
Okay, I agree with your answer, but I think that it should be an obligation and not, let's say, a discretionary judgment whether or not to consult the Commission.
No, but
the Commission
it isn't.
Has to be consulted. Is finally responsible for citizen of the proper management of the European funds. So I would say that this aspect should be analyzed, and maybe in the study you add and you propose that this consultation take place. First you have to check whether at which stage the national level, I mean the Commission is consulted, the OLAF or the managing department, and at what stage then afterwards the permanent chamber is obliged before they give this agreement to consult the Commission. This is my opinion. It's very important.
I don't know if any of you wants to add something.
I thank you very much, Francesco De Angeli, for his remark on that point. It is a good suggestion to further develop our study and the Trump project in the future. Actually, we do have a very, very detailed national report on Austrian legislation and also one on German legislation. And therefore, if the chamber deems it appropriate and the delegated prosecutor may so suggest, they can have recourse to these procedures. We will take into account also this in the further development of that study, or perhaps Dr. Innerhofer may well add a paragraph in his comment in proceedings if she feels like doing it. Thank you. Of course, all the countries. So guys, you have to do some extra work apparently. Does anybody want to add something? also people online. Is there any further question?
I think. Yes. Before the breakfast, the last announcement is about the guided tour for, of course, for people from abroad. So there is a tour guide, Daniela, which will wait for you in front of the hotel, the Fortuna Hotel, at 5:30. And there will be a walking tour at the center in the city, and it will last around 1 hour. I also would like to remind you that dinner will be at 8:15 at the Ristorante del Sole, and so all the speakers and also accompanying persons are invited to the dinner. So thank you again very much. We then also have an Italian session for those who are interested about the specificity of our legislation on this topic. So thank you very much. I don't know if coffee break. So.
Ben ritrovati, io